have George Ogubi right here in studio. He's a constitutional lawyer and will be getting to speak all matters to do with the hearings that are ongoing by the Justice and Legal Affairs Committee regarding 4 petitions to remove 4 IBC commissioners. George, thank you so much for joining us. Now, Vice Chair of IBC, Juliana Cherera, on Monday through her lawyer questioned President William Ruto's stance, and especially since he's expected to form a tribunal to determine their fate. Is this an argument that resonates with you?
First of all, thank you very much, Grace, for having me on this channel to discuss such an important issue that will determine a lot in the coming days. Number one, even before I respond to that question, this process is very interesting. Interesting for two things. Number one, for the first time we are seeing, or rather, what is unique about this process is that it is being led by those in government. If you look at previous commissions which have successfully been disbanded, most of that quest has been led by the opposition team. You remember the Kivuitu-led team in 2007, after the elections in 2007, 2008. The then opposition leader, His Excellency, the former Prime Minister Raila Odinga, led an ouster of the commission at that time. Subsequently, in 2013, again, he led the ouster of the Isaac Hassan-led commission. So it is very interesting this time to see that the ouster of a section of IEBC commissioners is being led by those in government. Two, it is the timing. We are just from an election. We are about 4 years or so into another election, and we are already seeing that the shape for 2027 succession politics is already taking shape. So it is very interesting for those two things. One, the time, and of course, the faction of government that is leading this ouster. Now, on to your question now. There is a principle in law that we call sub judice. Sub judice to mean that it is not right for persons to be discussing matters which our courts and tribunals. When you look at this JLAC committee, it is performing what we call quasi-judicial functions. And when you talk about quasi-judicial functions, you can equate it it outside the committee, then it raises a lot of questions even around the independence of the committee itself. And so, as much as the president, as a Kenyan, has got a right, freedom of speech and freedom of expression, the president should also realize that he sits. When you look at the process under Article 251, I think sub-Article 4, it provides for the functions of the president to the ouster of commissioners and even judges and anybody who sits in an independent commission. And so when you make such kind of comments on and you make them public, what that comment says is that you have even predetermined. And so even when this process reaches your desk, I mean, it will just be the process, but will these people be facing an impartial person? Will these 4 commissioners be facing an independent process, free from external forces? The answer is as good as mine. That tweet by the president did not go well, because it's like when you look at the judicial system, when you start from the lower court and you perhaps go to a higher court, and then you hear perhaps, let's say, a court of appeal judge making comments on a matter that is before the high court, and then the same matter goes to the court of appeal, do you expect that judge to sit and listen to the matter, having made comments, public comments? Your answer is as good as mine. An application will be made immediately for that judge to recuse themselves and another judge to come in. So those comments by the president were not right, and it is right for these four IEBC commissioners to raise questions around the impartiality and the independence of this process. Yes.
It's quite interesting you mentioned the tweet. Maybe if I can just the tweet. 5th November, President William Ruto tweeted, "And the lords of impunity who destroyed oversight institutions should allow Parliament to hold," and I quote, "rogue officials who put the nation in danger by subverting the democratic will of the people to be held to account. New order is a rule of law, not wishes of big men." Now, when this ability for a fair hearing, and what are the provisions within the law that can help perhaps to put the record straight, such that by the time the tribunal is being formed, the four commissioners have a chance for fair hearing?
Perhaps the procedure for their removal is provided for under the Constitution, and if Parliament, in their own wisdom, will find that these four commissioners conducted themselves in a manner that undermined the Constitution, then their work is very simple. They are supposed to forward that petition to the president, and the president, under the same article, Article 251, is supposed to get this petition. In the first instance, he may elect to suspend the commissioners in question, and after suspending the commissioners in question, then the president is expected to form or constitute a tribunal which will listen to these to the petition seeking to remove these four commissioners from office. Perhaps the only channel that these four commissioners have, for me, there are two. Perhaps going to court and saying that, you know what, we have keenly listened to the process, we follow the process, and we feel that the process is not as independent as it's supposed to be. It's not as impartial as it's supposed to be. There's already a predetermined judgment. And if they can prove that, then perhaps the court can halt the process. And also the tribunal that might be set up by the president, when it gets to that point, they'll be faced with this legal, because these are very serious legal issues. Because when the president is talking about rule of law also provides that there be a fair hearing under Article 50 of the Constitution. So when you talk about rule of law and the constitutionality, democracy, then democracy, constitutionality, and the rule of law provides that even you cannot be condemned and heard, you must be heard by an impartial body, by an impartial tribunal, by an impartial court, so that justice is not only done, but it is seen to be done. Exactly.
Yeah. Now, Azimio leaders have accused President William Ruto of witch hunt against those who are against him during the elections. Do you think these are fair accusations to the president?
Well, that question, I would answer it from a political point of view, because I don't feel there are any legal issues that are being raised there, but it raises questions of politics. You realize that two commissions have been ousted, of course, by efforts from former Prime Minister Raila Odinga, and many are questioning, is it only right for the IEBC Commission or the commissioners to be removed from office only when it is the former Prime Minister who is leading that quest for the removal of some or all of the commissioners from office? Or is it wrong if it is being led by another person? Why perhaps one would look at it as a witch hunt would be that the timing. I think Kenyans are facing very serious challenges and very serious issues that need to be addressed by this current regime. And if the president, in his own wisdom, feels that the removal of these four commissioners should form an agenda, a main agenda in his administration, then perhaps I feel he's missing the point. And he should redirect that energy perhaps and focus on making sure that what they promised Kenyans in terms of the economy and creating the jobs and making sure that the livelihood of Kenyans and in particular the hustlers, because that was his campaign slogan, are met. So perhaps the timing would be one that would lead to the witch hunt, because we are just from an election and he has been speaking very strongly against these four IEBC commissioners. So one would look at it from that point. On the other hand, one would not look at it from that point of witch hunt, because he has always wanted, the president has always talked about creating institutions which, according to him, should be independent, should be impartial, and should be free from, being directed from certain quarters. And if you read that tweet, he feels that these four commissioners were being or are still being directed from the handshake, because he was very categorical in his tweet. So that is how you'd look at it. But for me personally, from where I sit, the timing is wrong. We are still far away from an election, and this current administration should focus on other things other than the ouster of these four commissioners. Also noting that the tenure of the current chair is ending in January, and it is expected under the IEBC Act that the vice chair should take in an acting capacity. So the timing is what is bringing a lot of issues.
Now, George, at the beginning of these hearings last week, the four IEBC commissioners' lawyers questioned whether the committee had jurisdiction to hear the matter. George, what are some of the thresholds set by law that determine whether a committee has jurisdiction to hear a matter?
Well, again, JLAC, if you look at the committee, it was actually directed by the Speaker. When the petitions were presented before Parliament, the Speaker gave a directive and said that the committee that will listen to the petition and give recommendations to the floor of Parliament was JLAC. If you look at the procedure, well, the Constitution seems to be a little bit silent. It only talks about Parliament. So how Parliament elects to conduct its business, that is again subject to the standing orders and the Parliamentary Act. So when you look at the wording of the Constitution, it only says Parliament. So how Parliament decides to conduct its business is now subject to the parliamentary standing orders. And that is why the Speaker directed that, yes, these petitions have been brought to Parliament. We are tasking the JLAC committee to hear and determine. So the question of jurisdiction was settled by the JLAC committee, and they settled that it has jurisdiction to hear and determine. So for me, I feel that the wording of the Constitution has not prevented the JLAC committee from hearing and determining the petition for the ouster of the IEBC commissioners. Yes.
The Azimio Party had a parliamentary group meeting today where they resolved to postpone the protest to stand in solidarity with the four IEBC commissioners in the event that the protest continued tomorrow. What do you think the protest, the impact will have been to the hearings that are still continuing?
Well, sometimes in any democracy, if you go to the US, if you go to the UK, any mature democracies, demonstrations are allowed because we enjoy freedom of assembly, freedom of speech, and freedom of expression. So those planned demonstrations, were they wrong? No, they were not wrong. They are within the ambience of the Constitution. It is a right. Those are rights provided for under the Constitution. The impact perhaps would have put a lot of pressure on government, perhaps to say, oh, let us go slow on this process. Let us hear the commissioners, because some of the issues and concerns that even the commissioners are raising is that you remember one of the commissioners requested for about 14 days to put their reply. and the jailer committee declined to give those 14 days. So perhaps there would have been a lot of pressure. You know, sometimes when you look at, if you've worked around maybe civil society organizations, when they are pushing an agenda, when they are fighting for something, and, you know, when dialogue fails, you know, when you want to bring change, a policy change, a law change, you know, behavior, character change, sometimes you start by engaging dialogue. And we've seen quite a bit of disgruntlement, especially from the minority side of government, the opposition, where they are calling upon the Kenya Kwanza regime through the president that, you know what, go slow on this thing. We have other issues that are affecting Kenya that need to be tackled. So when that dialogue fails, and if you've worked with civil society organizations, it calls sometimes for demonstrations, because then it puts a lot of pressure. And if dialogue does not work, then they'll hear us through this demonstration. So if these demonstrations would have gone on, it would have slowed down things. And perhaps, you know, the government would have opened its ears and eyes to what the minority side of government is saying when it comes to this process of ousting the four IBC commissioners. Yes.
George, now IBC Commissioner Francis Wanderi today joined Commissioner Irene Masit in declining to respond to the petitions. Now, through his lawyer, Wanderi said he had not been furnished with documents that he could respond to. Also, Commissioner Justice Nyang'aya also said that he's yet to receive documents and information to enable him respond to the petition. Do you think this is something that can hinder them from appearing before the committee? What could be the reason that the committee is withholding to give them the documents?
Well, it was very interesting when I was following the proceedings today, and one of the petitioners even went further to allude that, you know what, when you look at the standing orders of Parliament, it only directs us to serve the petition, but it does not direct us to furnish the respondents, who are now the four IBC commissioners, with further documentation. I found that very surprising, because if I am accused of one thing or another, and that is a procedure in any court of law, and if these people want that this process to be declared unconstitutional for violation of one right or another, especially when it comes to fair hearing, then they proceed in the manner in which they are proceeding, because then they will give the four IBC to appeal before courts, the High Court especially, so that they enforce their fundamental human right when it comes to their hearing. So if you want somebody to respond substantially to a claim on an allegation, then you are required by law to furnish and present all documentation that you wish to rely on at the hearing, at trial, and that is normal practice, because it is enshrined in the Constitution. You cannot take it away. The right to fair hearing, you have to be accorded, and it means being furnished with all the evidence, all the documentation that the petitioners are relying on. So it was very funny to hear such kind of comments that there is no obligation to furnish the respondents with all the documentation and all the evidence that the petitioners are relying on. And for me, that would be a ground for perhaps the respondent to say, you know what, this process is not impartial, this process is not fair, this process does not abide by the rule of law. Yes.
George, let's just look at a scenario where the four IBC commissioners are removed from office, and now the IBC chair, Wafula Chebukati, and two other commissioners also retire. What is the situation like? How do we move forward from that? Is it recruitment of other IBC commissioners? What's the process like?
Basically, that is what is happening. You've already, in fact, I would take you back to a very interesting Gazette notice that was put up by the president sometimes in October, I think the
21st
22nd of October. It is very interesting that I heard about a new term, perhaps, I don't know, in the employment law, or I have never heard of an impending vacancy. The vacancy is either there or it is not there. We are slowly introducing a new term into the employment law, where we are looking at impending, looming vacancy. So that is again very interesting. But when these three commissioners proceed on their leave, and then the petition against these four successfully happens, what then will take center stage is that the commission now will be at the hands of the secretariat, led by the CEO, until when now a new commission with new commissioners, actually not a new commission, but new commissioners will be appointed by the president through the process that is usually there. And it's also very interesting to note that there is an amendment bill to the IEBC Act that has been flaunted by the majority leader, Honorable Ichungwa, when it comes to the selection panel, the panel that is charged with selecting new IEBC commissioners. Perhaps it looks like it is affecting the Public Service Commission, which had about 4 slots, and the amendment is proposing that the same be reduced to about 2 slots. So the onset of these processes that are happening now, it essentially means that it is a complete overhaul. We are looking at a complete overhaul of the IEBC itself. But let me talk about the negative effect or the negative side about it. When these 4 commissioners came into office, they found the current chair, Chebukati, and the other 2 commissioners. And therefore, they could learn from the 3 because they are fairly new. We were just about, and you remember it took quite some time for these 4 commissioners to be appointed in office. And it took time for them to learn the process because it does not elections. It has other duties and responsibilities mandated to them Constitution, IEBC Act. So when you do a complete overhaul, who will be there to guide the new commissioners that come in? Who will be there to see that? And that is why, if you look at the appointment of the commission, you realize that there is one who will leave earlier than the other, so that even when somebody else comes in, there is that room so that you train and you have sessions with the incoming team and tell them this is what happens here, this is what is done. So when this complete overhaul will happen, there will be a negative impact in terms of now the new commissioners who will they look up to? That is why the appointment of the commissioners, even look at most commissions, look at even the judicial system, look at even the composition of the Supreme Court. There is no time that all the Supreme Court judges will leave at the same time. There has to be 1 or 2 leaving, so that if those 1 or 2 come in, they find a group of Supreme Court judges who are there, and they are able to work with them, train them, and induct them into the process and how the Supreme Court operates and conducts its business. So this complete overhaul will be very prejudicial to the IEBC, and perhaps let us see. When a complete overhaul happens, then the secretariat led by the CEO will take charge.
Yes. Judge, even as we wind up, the vetting of the 51 principal secretary nominees is set to resume after the Labour Court dismissed the 3 petitions challenging the vetting process. We know that 5,000 CAS, already 5,000 people have applied for CAS positions, although the courts have declared that these CAS positions are unconstitutional. What are your thoughts on that?
Well, let us not, when it comes to the CAS's position, I think the court has made its ruling. And when you follow the proceedings of the CAS's position, the question that the courts grappled with was to be given a difference between the role of a CAS and a PS. And they could not give that clear distinction because these CASs operate in the ministries and the PSs also operate in the ministries. So when they could not give that distinction between the role of a CAS and the role of a PS, it was very difficult for the courts to say, yes, they are constitutional. And the courts declared themselves on that. When it comes to the PS, I think also the court has it has given its position. There was no justifiable reason to stop the vetting processes from going on, despite the petitioners raising very valid points as to why those processes should be stopped. Because most of the reasons that the petitioners raised, they were talking about issues of regional balance, gender balance, and the court has decided that, you know what, let the process proceed, and they do not find fault in terms of the appointments of those PSs. But for the CSS, I think the court is very categorical, and I believe the current regime should accept the verdict of the court when it comes to the CSS position. Yes.
George, that's all the time we had. Thank you so much for coming. That has been George Ogubi, a constitutional lawyer. We've